Good afternoon. Oops, I'm jumping the gun. Welcome to the Appellate Division First Department. We have about 6 hours of argument time requested. Therefore, only ask for the time that you need, not the time you want. We're familiar with the record. We're familiar with the briefs. If we have more questions, we will keep asking them, even if the time is up. People versus Crenshaw. Appellant? Respondent? 4, 2, and 4. Blasio versus Related Construction?
Request 5 and 1, please, Your Honor.
Respondent?
Respondent, London Fisher, 5 and 1.
Did you have a cross appeal?
No.
5 on 1 and 5. K Children is submitted. Almanza versus Anra, appellant?
Request 5 and 1, Your Honor.
Respondent?
Respondent, request 6, Your Honor.
5, 1, and 6. Merchants Bank versus 19 West 55th. That is submitted. Ho versus Star Contractors, appellant?
Request 6 and 2.
Respondent? 6, 1, and 4. National Auditing versus 511 Property. Submitted. Perella Weinberg Partners versus Kramer. Respondent? 5, 2, and 3. Brooks versus U.S. Express. Who are you here for?
We're here to respond.
Do you wish to submit?
No, it's a hearing, requested time.
Okay, submitted. Sid versus Kinale Capital Group.
Good afternoon, Your Honor. Appellant request 5 and 2.
Respondent? 5, 2, and 5. People versus Joseph Parker. Respondent?
Respondent request 3 minutes, Your Honor.
5, 1, and 3. Rock Group versus certain underwriters. Appellant?
Request 5 and 2, Your Honor.
Respondent?
3.
5, 2, and 3. 101 East 16th Street versus DHCR. Appellant?
3 minutes and 1 minute.
3, 1, and 5. People versus Tapia. Respondent? 5, 1, and 5. And Sandar Associates versus Corporate Habitat is submitted. People versus Crenshaw.
Step up.
Good afternoon, and may it please the court. Jane Merrill for Appellant Christian Crenshaw. Every additional day that Christian Crenshaw spends imprisoned is a day that he's not reaching his tremendous potential. Every day that he spends in prison is a setback to his future employment and financial stability. Every day he spends in prison makes him more likely.
Counsel, do the mitigating factors, which I acknowledge are substantial, do they, how do they balance with the aggravating factors? And specifically, what I'm talking about is really the extreme acts of violence committed here.
Your Honor, the facts here certainly are serious. There's no dispute about that. And Mr. Crenshaw, Christian, has never asserted that prison time is not appropriate here based on the seriousness of those facts.
But yet at the same time, he points to his co-defendant and says it seems unfair that the co-defendant essentially gets YO and is done, and he's stuck.
Absolutely, and that's not we're not asking for the same outcome here. We're not asking for equal treatment, just proportional treatment. And in part, Your Honor, that's based on the fact that YO is not just a sentence. YO also relieves the defendant of a criminal record. So the co-defendant in this case is walking away from one of the same acts as Christian with no criminal record and no prison time.
But you just acknowledged that in this instance, there were multiple acts, so doesn't that distinguish the two cases?
Absolutely, it does. But the appropriate response to that is not to both saddle Mr. Crenshaw with a criminal record and prison time. He was sentenced here upon a conviction for attempted murder to 7 years. That is in no way proportionate to his co-defendant's sentence, not a sentence, adjudication of youthful offender, so no conviction.
So wait,
Did
when,
he admit to firing the gun, though, which is a very substantial consideration?
Absolutely, he admitted to that.
Isn't that a pretty serious crime that would merit that type of sentence?
There's no question that it's a very serious crime, and this court has found that youthful offender adjudication is nonetheless appropriate for serious crimes, including homicide, manslaughter, things that escalated to much further degrees than the context here. I don't say that to minimize what Christian did here. He turned
and counsel,
himself in.
can I just, let me make sure, when he committed this crime, he had already had a juvenile delinquency finding, right, for having a gun.
He
So
had,
this was not his first contact with the system, and his last one was for gun possession, correct?
Your Honor, his previous contact was with family court.
Right,
Um,
for gun possession.
I know that it was for criminal possession of a weapon in the
So
fourth
then-
degree. I don't know if it was for a gun as I stand here now, Your Honor.
Yeah, I think it was a gun. And so then it escalates and he shoots someone in the leg and then someone else gets shot. There's not just one incident, there's a couple of incidents, right?
There are two
And
incidents.
what was his maximum exposure?
I don't have that in front of me right now, Your Honor, but this was he was not a predicate. He was not being
Right,
treated
but
as a predicate.
so it would have been, say, 15,
I
right?
believe that's correct.
And he got 7 here, right?
That's correct.
Okay.
And all of that is, the context of that is that Christian, before and after this occurred, he was stabbed, he was shot at, and he was shot. And I don't say that again
But does that justify shooting basically into a crowd a couple of times?
Absolutely not, Your Honor. And it's not a justification, but it's context that Christian is not merely a perpetrator here. He is a victim, and although his behavior was conceitedly not normal, neither was his childhood, neither was the community where he was growing up. These
Thank you. You'll have time to rebuttal.
Thank you.
May it please the court, Charles Wan for the respondent. Your Honor, as the sentencing court pointed out, defendant here was involved in 2 shootings, and although the co-defendant did receive a useful offender adjudication, he was involved in the second shooting where there were no victims. Defendant pled guilty to the first shooting, where he admitted to having shot the victim with intent to kill, and the court actually allowed him to plead guilty to attempted murder for 7 years.
So, counsel, can I ask you to differentiate this sentence from the sentence of his co-defendant?
Well, as the sentencing court pointed out, defendant was involved in 2 shootings, and the one he pled to was where an individual was shot and defendant admitted to having shot the victim with intent to kill. The co-defendant was involved in the second shooting where, as far as we know, there were no victims, so that was the only his involvement.
And did the second defendant have a criminal record?
The record is
don't
not
think
clear as to what his record was. I'd assume he wasn't, as he was given a useful offender adjudication. His was separate, so there was no mention of what his priors were. The only facts we really know is that he was given useful offender and he was involved only in the second shooting.
And you're not opposing the vacator of the surcharges, all the surcharges, right?
We take no position on that, Your Honor.
Okay.
This was a negotiated plea.
Yes, Your Honor. As I point out, the court offered him 7 years, which was less than the 10 years offered by the people. The court said he had considered everything. Defendant was not deserving a useful offender education, but did offer him 7 years plea offer. If there are no further questions, people request an affirmance.
Thank you.
Your Honors, it's absolutely correct that there was a victim in this case. That's never been under dispute. That's never been contested, and Mr. Crenshaw takes that extremely seriously. In his letter to the court, he acknowledged not only the harm that he did to the victim here, but also his responsibility to his community and what he did there. The fact of that victim does not militate against a youthful offender adjudication. A youthful offender adjudication is entirely appropriate. I would refer this court to a recently decided case, People versus Jason Williams. In that case, where this court reduced the sentence to concurrent terms, there were also two incidents. There were two incidents, one where someone was shot in the leg, and the other where someone was violently assaulted. In that case, this court reduced the sentence despite there being victims. And this is a very different case. These incidents were not...
We reduced it because we said concurrent, okay. But we didn't say not youthful offender.
That's correct. I bring it up just to point out that there are differences here, and that even when there are victims, that a reduction can be entirely appropriate. And at minimum, that reduction is appropriate here. This is not a case where Christian had been arrested and released and then committed a new crime. These incidents were separated in time by about a week. And I would note for the court that the first incident came about 18 hours after Christian himself was shot at. In between his arrest and in between the incident and his arrest, Christian was shot. This is simply not a bright line between victim and perpetrator.
Do we know that the person he shot was actually the person that had shot at him the day prior?
No, Your Honor. There's no evidence of that in the record. I do think this circumstances very strongly suggest, if not that this was the same person, that Christian's shooting was in response to that shooting. I see that I'm out of time. I do ask you to adjudicate Christian a youthful offender. Thank you.
Thank you. Blasio versus Related Construction.
Good afternoon, Your Honors. Chris Savro from Associates, Subin Associates, on behalf of the appellant plaintiff, Jimmy Blasio. This is a very simple case. There was an unguarded opening on the staircase. The plaintiff fell through it. He sustained horrific injuries as a result. It's a very clear violation of the labor law. I don't think there's any...
What should we make of the affidavit from the foreman, I think Mr. Akalko, who says that the plaintiff and his coworker had screw guns and could have removed the barrier, the plywood barrier on the stairwell? What should we make of that?
I think we should make absolutely nothing of that. It's purely speculative, and Mr. Akalko is the one who gave them instructions. If you wanted to be more explicit, he was there on that day. He responded to the scene. He could have said what he instructed them to do, what he investigated afterwards. Mere speculation that they might have removed it is of zero evidentiary moment. I don't think it's an admissible evidentiary piece, even in opposition. And even if it were, as we note, there's countless cases in the first and second department that say that this is merely an issue of comparative negligence, which isn't a defense under 240 sub 1. So really the court has a choose your own adventure situation here, where every possible outcome leads inexorably to the fact that the defendants are liable under 240 sub 1. Either they are bound by their prior admissions before the DOB in their own investigation, showing that they have no offense.
There's been no discovery in this case. Why shouldn't we say it's premature, get depositions to understand whether or not, to what occurred?
Well, Your Honor, as we know in any number of cases cited in our brief, Laporte, Thompson versus Pizarro, in which Your Honor witnessed me getting a browbeating on the defense side, depositions need not proceed in order for liability to be established.
Though that one of the co-worker who could be a key witness in this in terms of what happened has not been deposed. And he's clearly someone who might have some pertinent knowledge to some of these issues.
Yes, Your Honor, but in order to demonstrate prematurity on that ground, they have to form some evidentiary basis that there's a coworker that has evidence. Mr. Akalko, he's their supervisor for Roki. He doesn't say that anyone has anything. Mr. Calderon, the site safety supervisor, responded. He investigated the scene. He took pictures of the barrier beforehand. He doesn't have any information.
No, but I'm specifically asking about the co-worker who worked with him who could have information.
Chavez.
Chavez was already investigated. He doesn't have any information.
How do we know that? Because he wasn't deposed yet, right?
But there doesn't need to be a deposition. They already investigated. Chavez did not do it. The plaintiff averred in his reply affidavit.
Did they have access to Chavez?
Yes, they took Chavez's statement at the scene of the accident. Mr. Calderon took his statement as part of their investigative reports. And so really, they investigated afterwards. They investigated before the DOB. They investigated in response to our motion. And what evidentiary proof do they have that there's further depositions that are warranted, that there's another investigation that's going to lead to a different result? Really, all we have here is multiple bites of the exact same apple.
So it's your position that they could have easily spoken to Chavez himself. He worked for them, so there's nothing to stop them from speaking to him, and they did, in fact, speak to him.
Absolutely. And instead, all we have is mere speculation that perhaps there's another employee out there, but they also have access to all those employees. Again, Mr. Okoko was there.
Was anyone identified other than him?
But if we're going to the standards of prematurity, Your Honor, that's their burden to show.
Right, that's
we
what I'm
can't
saying.
control it. The plaintiff.
Did plaintiff identify anyone else?
No, the
did
only people that
defendant?
we know that were there were plaintiff and Byron Chavez.
And defendant didn't, the accident report didn't say anything about anyone else, right?
Correct.
Right,
Correct, Your Honor. And they offered no defense before the DOB when they had an opportunity to. And I think really, if we want to hang our hat on estoppel, that's the equitable result, right? Because before the DOB, they had an interest in saying, hey, we had this plywood barrier installed. There was fall safety in place. We were not in violation. We did not create an immediately hazardous condition. Instead, we have Mr. Calderon in his own investigative report referring to the open barricade, the unguarded stairwell, as a fall hazard. We have Ms. Reckenmeyer of Related Construction also admitting that it was a hazardous condition in sworn writing before the DOB. We have their own counsel, Jennifer Chen, who also admitted at the oath hearing that, yes, we violated this, we created an immediately hazardous condition, we've corrected it, please let us go back to work. Estoppel was created for these issues. And if we're going to discuss prematurity again, they have provided zero evidentiary proof. I'll refer the court to their own decisions in Laporte and Thompson versus Pizarro. I will also say that I feel I had a much stronger defense in Thompson versus Pizarro. The plaintiff submitted a police accident report memorializing two different versions of the accident, one in which the plaintiff told the police that I moved forward and the bus turned into me. The other was that the bus driver said that the car came up while I was making a wide turn.
Not sure why we're talking about that. Anyway, your time's up. That has nothing to do with this case.
Well, I lost in that case without
I know, but that has
depositions.
nothing to do with the argument in this case, so.
Fair enough, Your
Going a little far field here. Okay.
May it please the court, Joe Curso for the respondents. This case is, like counsel said, it's simple. Discovery has not been
This
complete.
case is what?
This decision is simple. There's been no discovery. Defendants have created.
But you know, as your adversary points out, I mean, there's a lot of case law that says that irrespective of discovery, if prima facie case is made out, we go along with that. And in this instance, what discovery do you need? You have the foreman. He submitted an affidavit.
Defendants have established in rebuttal that discovery is required, deposing the plaintiff, deposing Chavez, conducting further.
Well, wait a second. So you have Chavez, you had him, he's your employee, you could talk to him anytime. You don't need to have a deposition of him, right? Plaintiff gives an affidavit. Is there anything in the affidavit any evidence that you would point to that would dispute any of the evidence that plaintiff gave in his affidavit?
Well, I think the affidavit is an issue for a jury to decide. It's a credibility issue.
No, only if you raise it, only if if there's something there that says that this might be incredible. There's nothing.
We had the site safety manager's affidavit. He said he installed it. It remained there before the date of the accident.
Counsel, question is, what evidence is there other than speculation that the plaintiff removed the plywood? The fact that it was removed is not evidence of plaintiff removed. The plaintiff denies removing it. And what evidence is there in the record that's admissible that plaintiff did remove it, or what discovery would you take that you couldn't have already taken that would show that plaintiff removed the plywood?
The trial court's decision did not rule on prematurity, but to answer the question, additional discovery would be required. Reviewing the meds, seeing what he says happened, speaking with the plaintiff. He was not spoken to on the date of the accident. He was unconscious.
You're saying that if you, because this is not normally enough, it sounds like you're saying that if you spoke to him, he would contradict his very clear statement that he did not remove the plywood. And usually we don't allow that to be a basis for saying it's premature on the hope that someone will contradict a clear statement they've made in an affidavit.
Yes, thank you, Your Honor. I do not believe it's speculative that the plywood barricade was sufficient to prevent the accident.
That's not the question. The
wasn't
question
there.
was who removed it.
That is
It
the
wasn't
issue.
there, so that's the only way that he would be liable for its removal or would any way affect him, putting aside the comparative negligence issue, is if he removed it. So that's what you'd have to show to get around the fact that someone else removed it, he's still entitled to labor law protection.
I believe if he directed Mr. Chavez, he would be also the sole proximate cause.
Well, Chavez gave a statement, and in his statement, he simply said that his partner lost his balance in an area where there was no protection, and he fell over the stairwell. So there's nothing in there to indicate that somehow either the plaintiff told Chavez to remove it, or that Chavez removed it, or that the plaintiff removed it, or that anyone else in their presence removed it. Simply that there was no barrier there to prevent his fall. So what more could you get, and from whom?
It is true that the barrier was not present at the time of the accident, but it was present prior to, and additional discovery is needed to establish who removed it. Right now, we have nothing.
No, wait. Not from the plaintiff. You've got plaintiff statement saying, I didn't remove it. You've got Chavez, who's your employee. So the only way that this would be premature if you would need something from plaintiff, but you haven't identified anything from plaintiff or any part of plaintiffs that you would need. You could have done Chavez is your employee. You could have spoken to him every day for a year after this accident. So you can't use Chavez as your reason for staving off summary judgment.
It wasn't using Chavez, it was just addressing the sole proximate cause of.
Okay, so what do you have? What evidence have you put in to raise an issue of fact as to that issue, other than the fact that there is no barrier? And at one point there was a barrier, and now there's no barrier. Other than that, what do you have?
The barrier was there. It was next to it at the time of the accident. They had the means
Other
and
than
methods to
that,
remove
the
it.
fact that the barrier wasn't there, what else have you put in?
Our opposition makes clear that discovery is required, and I understand you're saying in the possession of the plaintiff. That is the information that is needed.
I'm saying you could have put up whatever you had to raise an issue of fact, and plaintiff has denied it, and you haven't put in any evidence that would give us a reason to doubt that. That's all.
We believe it's a credibility issue of whether the plaintiff is being honest in his affidavit.
Thank you.
Your Honors, I just very quickly like
Do
to
you
just.
respond to your adversary that it's really credibility, it's plaintiff's credibility, and they should get a deposition?
Well, I think that's purely speculative, and it's not enough, as Your Honors have already pointed out. But also, the cases that
We
I
don't
wanted to
point
point out.
anything out, we just ask questions.
Okay. As Your Honors questioned, yes. But I would also like to highlight the fact that even under their speculative theory, even if he's not credible, it's not a defense. Or for the court, first to Justice Kearns, you decided Sotoriba. In that case, in Sotoriba, the plaintiff climbed over the barricade, and that was deemed to be merely comparative negligence. That's not a defense. I would also like to refer the court to this court's earlier decision in 1997.
Wait a second. Are you saying if he purposefully took that barrier down without anybody asking him to do it on his own because he just didn't feel like seeing it, that wouldn't raise an issue of fact of sole proximate cause?
Well, I am saying that, but also
I mean, there's one thing to say I climbed over something that's already there, as opposed to I purposely took down something that I was told to leave alone is in place for that.
But Your Honor, they never told him to leave it alone.
Well, so that is okay.
That's also not an issue of fact because he was instructed to install these panels on the staircase.
Thank
right?
you. Ho versus Star Contractors? Oh, I'm sorry, wrong case. Almanza versus Anra. My apologies. You didn't even mind that I was skipping you, huh?
So upset.
I'm going, what case?
May it please the court, my name is Dan Ratner. I represent the appellants on this appeal. It's a medical malpractice case, wrongful death case. We're asking the court to reverse the denial of our summary judgment motion. And the reason for that is that in response to our motion, the plaintiff's experts came up with nothing more than speculation and guesswork. And the reason I say that is because our experts said that there was basically a routine epidural procedure during labor. There were no signs or symptoms of any type
Well,
of.
let's just focus on the autopsy report. Don't the plaintiff's experts note that there's certain preparations that might suggest that it did go into the vessel?
Well, the autopsy report does have a phrase in there about possible perforation. I will grant you that.
So why isn't that the record evidence that there was some damage to the interior vena cava, which could have caused this bleeding out?
Because
Why isn't that the record evidence?
because medical malpractice cases are made using expert testimony. And this expert seemed to be saying that because someone else suspected a possible perforation.
But it's based on...
The two main arguments you made, one was that the needle could not have gone in far enough, and the plaintiff's experts strictly addressed that and said, based on the plaintiff's stature, it could have gone in far enough. And your other big argument is that there would have been damage to the spine, but the plaintiff's expert gave a very concrete explanation why there wouldn't be any damage to the spine and why there'd only be one going in and then a movement. So why, assuming you made your prima facie, why wasn't plaintiff's expert sufficient to raise issues of fact?
Well, I think Your Honor might have skipped over a much more important element of this, which was that our experts said that it would have been immediately apparent if there had been a puncture.
But except that the response was by the other expert is that there was a ceiling which later opened up. Now,
So that's great. I'm glad you asked me that question. Let's talk about that. It scabbed over. When? And if it had scabbed over, what about the fact that our experts said that everyone in the room would have known there was a problem because blood would have been drawn back in, right? At the risk of sounding a little informal, the plaintiff, the decedent would have jumped off the table. The nerve damage. Nobody addressed that. Now, yes,
I'm not saying if it perforated the interior, I can't even say it, the interior vena cava.
Vena cava, IVC.
That's why I could never be a medical
Yeah, me
malpractice attorney. But let's say it perforated it. That's not nerve damage.
But the point would be that
Can it have perforated that without causing any nerve damage?
I
Is that impossible?
guess this is what gets above my pay grade too, but I don't think so. And my point is the reaction would have been there.
But why would she have jumped off the table if it didn't touch a nerve? Because that's the plaintiff's argument. It didn't touch a nerve. What it did touch was the interior vena cava, which is what later caused.
What our experts said was that if it had been done wrong, then there would have been no pain relief during labor. The epidural would not have worked.
What about if it had been their theory, which I'm sure they'll articulate, is that it went into the vena cava, then it was withdrawn without being totally withdrawn and put in the right place, in which case there would be relief.
Right. So, and the testimony in this case was that when you make more than one attempt, when you have to move it around, that's the kind of thing that will be noted in the record. What the undisputed evidence is that he did it very routinely. One attempt, and it was done. So what we're having here is a lot of speculation about what may have happened.
so what caused this woman's death? What do your experts say?
Well, they said there was a spontaneous hemorrhage that is known to medicine. By the way, we don't have.
How rare is that? And how rare is it in a person presenting like the decedent here, as opposed to maybe another patient who's under other medication?
We said it was known in medicine, but let me just add, we don't have the burden of proof in this case. We did everybody somewhat of a favor of coming up with an alternative explanation, which is not our burden to do. Our burden was to show that we did not depart from the standard of care and that there was no proximate cause. And there was none. There was none. Not only did he speculate about what may have been happening during the procedure itself, when there's no evidence of that, after that, the experts speculated that, well, maybe she was constipated, and maybe it happened when she was going to the bathroom after this so-called scabbing over that reopened the wound. That's all speculation.
None of that's germane to the real issue here, which is whether they created issues of fact based on your expert, in response to your expert's testimony. How it opened up again would not really be germane to that burden of proof.
Well, it's easy to say that if an expert gives an alternative, a competing opinion is a
As
question
long
of
as it's
fact.
based in the record.
I don't agree with that, Your Honor. I think that the expert gave a very, a very nice sounding opinion, but it was all built on speculation and assumptions that are about evidence that is not there.
Okay, so let's hear from the other side and see what their argument is.
You think he's going to disagree?
Yes.
Good afternoon, Your Honors. May it please the court, David Stanagar of the firm of Kellner and
Counsel,
Kellner
what is,
for the
what
respondent.
is the evidentiary basis for your expert to say, in fact, that there was a perforation of the IVC which sealed and then the needle was put in the correct position?
The evidentiary basis are the forensic findings from the autopsy.
Wait, go back a second, because his argument is that there's no evidence in the record that during the procedure, the needle went in, was withdrawn again, and then put back in again in any way. There's just no evidence in the record of the procedure itself. So how do you address that? Because going to the autopsy doesn't really address what happened during the procedure itself.
Sure. How we address that is part and parcel to our expert's opinion was that they failed to recognize this when it happened.
You mean that they withdrew it and put it back in and didn't recognize that was occurring?
He repositioned the needle without removing it from the skin.
And that he didn't realize he was repositioning it when he did it?
He would have realized he was repositioning it, but he wouldn't have necessarily realized he perforated the IVC.
Right, but he's saying there's no evidence in the record of a repositioning during the procedure. That would have been something that would have been noted, and it was nowhere noted in the record. That their testimony is they just went in, it worked, and that was it.
Would that have been something that the defendant would have had to have placed in the chart? That it was repositioned and that somehow after he went into one place, then he went into another?
It certainly should have been documented, but as we stated, they did not. That would not be unusual for a medical malpractice case where oftentimes untoward events aren't documented in the chart.
Now the defense expert comes up with an alternative explanation as to why this occurred. Has your expert refuted that alternative explanation?
Indeed, it's our position that both of our experts have refuted that by citing directly to the forensic evidence in the record. Namely, if you take a look at Dr. Bernstein, their anesthesiology expert's affirmation that he submitted, nowhere in there does he give any treatment to or even indicated that he reviewed the autopsy report. He completely ignores the forensic findings in the autopsy.
Putting aside the autopsy for a second, I know which is what you're really arguing, that the autopsy shows damage. What about their prima facie position that if that had happened with the needle, the blood would have been drawn out at that time and they would have seen it immediately and that there was no evidence of that during the procedure? What's your response to that?
Well, they documented no evidence of it in the chart. I mean, there's no question. They don't document any return of blood in there. But again, that was part and parcel to the fact that they seem to have failed to recognize that this happened.
So they wouldn't have recognized if it was full of blood. They wouldn't have missed that if that had occurred.
It obviously did happen here.
We seem to be missing the big concern here, which is their point is there was no perforation, right? And there was no indication that there was a perforation. Your experts say there was. What was the record support that there was a perforation?
The blood clotting on the exterior of the IVC wall that demonstrates the healing process had already begun. Blood does not clot after someone dies during an autopsy, as they said. This demonstrated the chronicity of the bleed. This area of clot was found right in between two corresponding defects to opposing sides of the IVC vessel wall. These were determined to be possible perforations by the autopsy report. Now, the pathologist who did this found no other potential source of the bleed anywhere in the patient's anatomy inside Ms. Bahana's anatomy, despite doing a second Y incision and examining the lower areas of the pelvis as well as the legs. Additionally, there are no perforation marks in the segments of the lumbar vertebra that were resectioned in the anthropology report that appears within the autopsy report. This is consistent with a needle that actually missed the spinal column and as it traveled after being passed through the skin too laterally, striking the IVC and causing those two corresponding defects on the opposing side of the wall. Furthermore, the theory they've set forth here of the spontaneous retroperitoneal hemorrhage, this is an exceptionally rare event. Both sides here are saying that a very rare thing happened. What we're saying is it's only our theory that has forensic evidence supporting it. On the other side, they're saying that this happened, it can happen within 3 to 72 hours, although the bleed really opened up outside of that 72-hour window in this case. It was more like 78 hours. Our expert explained that our pathology expert, who's the chief deputy medical examiner of Cleveland, says he's actually performed autopsies on women who've had these spontaneous hemorrhages, and he found tearing of the splenic arteries and of the arteries passing through the pancreas. Our anesthesiology expert notes that in these cases, these women tend to be on anticoagulation therapy, blood thinners, and there's no indication that the decedent was in this case. Based on this confluence of forensic evidence, the only plausible explanation, according to our experts, is that this was an accidental perforation which not only occurred but was unrecognized by the defendant's appellants as they performed it.
No, you're not saying they didn't recognize it. You're saying they lied because all the signs of what you think happened, you're saying they didn't note in their charts, right? You're saying they
Correct.
you're basically saying they lied, and that because they didn't put any blood flowing, they didn't put any of the what you're saying results are in.
Correct, Your
Okay.
Honor. Just as if someone, burglar, breaks into your house to break in and burglarize it, they're unlikely to leave a signed confession note, but they might leave behind a fingerprint, which is forensic evidence. Thank you.
I'm just going to go back to my original statement. They are referring backwards from the autopsy report, and they still have not answered the question. So when did this puncture scab over? When did that actually happen? There's no evidence of any kind of reaction at the time. Blood being drawn back into the
How do you
needle.
respond to the argument that there was blood clotting, which suggests that well, it would suggest that there was a perforation?
Well, our experts say we're not even sure if the sample that was viewed by the pathologist on the autopsy report, it was at or near the alleged.
So you're attacking
perforation.
the autopsy report,
Well,
correct?
there's some issues with the autopsy report.
Doesn't that sound like that just really raises issues of fact, and that there should be cross-examination, vigorous cross-examination of the person who performed the autopsy?
Well, if we were to go to trial, obviously we would have a lot to work with, but I have to go back to, this is an expert who speculated that the needle must have been inserted at an extreme angle. Where is the evidence of that?
Well, I mean,
There was
basically what he's
scabbing?
saying
Where's
is
the
that
evidence of that?
your doctors did it and then didn't and recognized it and didn't say anything about it because they recognized that it would be a problem. But there is obviously evidence that they've pointed to of the result, right? The hemorrhaging,
It's a
the
complicated,
clotting.
it's a
the-
complicated outline.
right?
You use the word lying. I would prefer to use the word lack of evidence to support an opinion and speculation. And that's why we win summary judgment. When an expert offers a speculative opinion that has no evidentiary foundation.
Thank you.
Thank you, Your Honor.
Poe versus Star Contractors.
May it please the court, Dean Cho, counsel for the plaintiff's appellants in this action. The lower court's error in dismissing appellants' claims for breach of fiduciary duty, fraud, and negligence appears to be based on its overly simplistic misapprehension that
What is precisely your breach of fiduciary claim here? It's based on the lien law. What precisely is the claim?
That they failed to pay the subcontractors and vendors on the project, which they were statutorily obligated to do. They were,
But are owners trustees of lien law funds?
this, the general contractor is the trustee. Of
Right, so what's your client's connection to the lien law then?
They're the homeowners.
Counsel, what do you do with the case law in our department, Epstein and Farrow, which specifically hold that owners are not people who can bring lien law actions and claim a fiduciary duty, which seems right on point to this case. So how do you get around that case?
Well, that case, the case that they cited, Albstein.
Those two cases. That
Yes, and I believe it was the Ferro Fabricators. Those cases do not identify the plaintiffs as being homeowners. They are property owners.
So what does it matter?
Because the statute draws a distinction. As the second department in Ippolito recognized, the general rule is property owners are not fiduciaries under the lien law.
Well,
I mean, are not owed fiduciary duties under the lien law. However, in the sections of the lien law that we cited, and Ippolito recognized, there was a carve-out for homeowners.
What is your support for limiting Alpstein and Farrow to property owners as opposed to homeowners? What's the support in the decision that supports that distinction?
Well, the logic and the discussion in the Ippolito case, which specifically discusses the provisions of the lien law that we invoke, which are nowhere mentioned in the Albstein case or Ferro Fabricators. So and it's a very crucial, important thing to recognize because the appellate division is one court, regardless of the division, the departments. And
right, but we sometimes disagree with each other.
Yes,
that was my impression, looking at Ippolito, that it was just a disagreement between the
but
departments.
if they can be reconciled, and here they can.
And why should we even reconcile when really it's dicta? It's not even their primary holding. I mean, they didn't really have to reach the issue, correct?
It's not dicta. Because
They
expressly cited lien law 71A4 as grounds for saying this is why the breach of fiduciary duty.
Was it relevant to their ultimate holding?
Yes, it was the cornerstone of the whole.
No, wasn't Ippolito dismissed on res judicata?
No.
Yes. Ippolito? Wasn't the ground for dismissal in Ippolito res judicata?
But it was also,
No, it was res judicata. You don't go any further if you dismiss on res judicata, right? And also in Alpstein, the people were homeowners, right?
no, they were not. They just referred to the apartment as being the plaintiff's apartment. They never said it.
Oh, okay. So
No, because.
But I mean, honestly, you can see how that sort of threading the needle doesn't sound right.
But how can the dismissal be reconciled with the provisions of the lien law? Essentially, the dismissal of our breach of fiduciary duty claim was essentially a negation of the lien law. Because the lien law clearly provides that the general contractor holds.
The general contractor definitely is a trustee of the funds that you paid.
And
it's only you that it's not. Go forward. Let me ask you about your other claims. Your negligence claim.
Yes.
What negligence was there other than I didn't perform what I was supposed to perform under the contract?
They performed their work in a very hazardous manner. For example.
It doesn't matter. They could have done, if they didn't perform, no matter how they performed, it's a contractual breach.
But there are building codes.
So you have to allege a legal duty that's independent of the
Yes.
contract, correct? So what is the legal duty that you have alleged independent of the contract?
Yes, statutory duty under the building codes, state-enacted building codes enacted by the state legislature, which specify how certain work is to be done to avoid extremely.
And isn't that part of your contract, that you will perform your work in good workmanlike manner, in the way, and all of that? Isn't that all covered under the contract?
No, Your Honor, because.
You're saying that under your contract, they don't have an obligation to comply with the building codes?
There's no provision specifically stating that they're obligated to provide, to comply with the building code. Furthermore.
Wouldn't that be, if they don't comply with the building code, wouldn't that be just a black letter breach of contract?
But also, that issue is also complicated by the fact that the contract was only with, the trial court held was only with regards to the corporate defendant, Star Contract.
Right.
They were individuals. who
They
made-
signed on behalf of the corporation?
Yes, but they were also named as defendants under.
So you're touching now on the fraud, because presumably that's how they come in, through fraud, correct?
Yeah, fraud and also negligence, a breach of fiduciary duty, because under the lien law, officers of a corporation, a general contractor, are also personally liable, even subject to criminal sanctions for misappropriation of
Right,
money.
by subs, by the folks who should be paid, correct?
No, but also by the general contractor. Ippolito specifically said, and also trial courts in this department have also adopted the Ippolito reasoning, saying that there's a carve-out for homeowners. They're a protected class under the statute.
Thank you. You'll have time to rebuttal.
Good afternoon, Your Honors. Darrell John, Conway Farrell for the respondent. With respect to the lien law, I think the lower court got it right when the lower court said there's not a claim by any lien holder of the funds. The note of issue has been filed and there's still no claim.
Ippolito.
I'm sorry?
What about counsel's reliance on Ippolito?
Ippolito in the second department is in direct contrast, a line of cases in the first department. The first department, in Alstein, the owner is the owner of an apartment.
Well, maybe we can surmise that. The question is this: does it matter what kind of ownership there is under the lien law?
There is no distinction under the law between somebody who resides as opposed to owns an apartment or a residence. The distinction that the appellant is making in order to try to not fall within a long line of precedent in the first department is not viable.
What is the flaw in your view in your friend's analysis in his brief of Lien Law Article 3A, and in particular his citation to Section 71A-4, that in his view allows for this or compels this distinction between a homeowner on the one hand and every other type of owner on the other?
The homeowner and the property owner essentially have the same rights under the statute actually says real estate owner. The courts have said property owner, homeowner, they're all real estate owners. I don't see any legally distinct basis to treat one class differently than another.
Thank you.
Your Honors, I would just cite some of the trial court decisions in this department. 610 Park East LLC versus Best & Company, as well as 514 West 24th Owner LLC, which specifically note that homeowners are a protected class under the lien law, and therefore are to be treated differently. That they can, quote, owners who enter into a home improvement contract with a home improvement contractor can be trust beneficiaries under the lien law. And so the case...
Aren't those cases, aren't they maybe inconsistent with our holdings in Alberstein and Farrow?
Excuse me?
Are the cases that you recite, are they inconsistent with the appellate division holdings on this issue?
They would be, unless you reconcile the fact that these cases that we cite specifically address the lien law and specifically note that the plaintiffs are homeowners. While Alberstein, there's no discussion of the lien law at all, and and there's no identification, no express identification of the plaintiffs as homeowners, as opposed to being like the owner of condos for investment purposes.
Thank you. Barilla Weinberg Partners versus Kramer.
Good afternoon, Your Honors. May I proceed? May it please the court, Marin Shaw from Quinn Emanuel, Urquhart and Sullivan for the appellants. And I want to go straight to the question that I'm sure is top of mind here.
Why are you here?
Thank you. Yes,
We've
feeling that
decided
would be
this,
the first
whether or
one
not
out of the
we think
gate.
it's right or wrong, we are big fans of stare decisis in this court. So separate and apart from the merits, we've decided it twice already and quite recently. So how can we possibly go any other way in this matter?
Understandably so, Your Honor, and I'll give you two reasons. You did note that it's been decided twice already. It has, but if you look at the briefing and issues raised to those two courts, in Reparthy, first of all, and in Canthan, which I know two of Your Honors sat on the panel for, you'll see that this particular issue of the temporal reach of the No Loophole Act amendment to the New York labor law was not given fulsome briefing or consideration in the same way as was not given the fulsome treatment and consideration and briefing in the way that it's raised in this appeal. And what I mean by that is this.
You mean that you did a better job than the lawyers did?
No,
Your Honor.
That's
basically what you're saying. I did a much better job than the last guy.
I wish I could. I wish I could take credit for that.
That's what you're saying.
That's not what I'm saying.
What are
Your
you
Honor.
saying?
What I'm saying is the briefing in Reparthy, which was the first case, the appellant only raised this issue of retroactivity in reply for the first time, and it was
we clearly tackled it on the merits.
You did, but in Reparthy, it was raised as one of many issues and only in reply. In Canthan, which is the decision that was issued recently, it was not raised or briefed by the parties at all.
Let me just ask you this.
Sure.
Would we have to overrule our last two decisions to come to the place you want us to go?
Not necessarily. So
Okay,
I'm
how
glad
could
you
we
asked that.
possibly not overrule those two?
Because those...
Both of them have said it's not retroactive.
Yes, they have. But
That's what you want us to say. It's retroactive, right?
You don't have to say that in order to rule for us, Your
Okay,
Honor.
what do we have to do?
Here's why. Because retroactivity and the retroactive effect of a statute is only considered when the statute is deemed to have substantively changed or altered rights, liabilities, or duties of the parties such that it would be unfair to subject people to the statute whose conduct preceded the amendment, right? And I would point Your Honors to the Regina Metropolitan case.
Again, how do we get
You're
there?
going to the merits.
No.
I'm confused, to be honest.
The reason is neither Reparthy nor Canthan addressed the predicate question that we raised in our briefs, which is...
But essentially, you're arguing that those cases were decided wrongly and we should hold otherwise. And there are times we've done it. Generally, it requires when there's a split in the departments and we've looked at the issues and say, okay, we agree with the other departments. But here, we don't have that. So you're asking this panel essentially to overturn what prior very close in time panels did.
Yes, we are, Your Honor. And I think you can do that both under the doctrine of stare decisis and to give fidelity to the legislative intent. And here's why I raise it again, because you can do this on retroactivity. You don't have to, because to apply a statute to a pending case, you don't need to reach the question of whether it needs to be given retroactive effect in order to apply what it says now.
I'm totally not following that argument. I'll be frank with you at all.
Here's what I mean by that. The No Loophole Act is distinct even among other remedial amendments in that if you look at the text of the act doesn't change or alter or modify a single word of the original text. That's different.
Under the original text, your client was clearly not protected under the state of the law as it existed.
We disagree, Your Honor, because the No Loophole Act...
If you're arguing the original case and there's no basis for renewal, because the only basis you could possibly have for renewal years and years later is that there has been a change in the law. If you're saying, no, I should have won under the original law so I don't have to deal with retroactivity, then it's not a renewal motion.
I understand. It's a little bit more nuanced than that, Your Honor, and I'll move off this if you'd prefer me to address retroactivity.
I mean, if you could explain in a way that would make sense, but I'm still not following
There's a difference between a change in the law. We're not saying that the statute didn't change.
You're saying that we interpreted the statute incorrectly originally, and the
Some
legislature attempted to correct that.
I'm saying this is the important distinction, Your Honor. Some courts, not all courts, This is the distinction. Some courts,
Then you're also asking us to overrule ourselves, our other cases, which we're also bound by stare decisis.
Yes,
But I'll hear from you. But it's the same exact issue, because we ruled clearly under the prior law that it would come out with the same result. So for us to accept this argument, as my colleague clarified in what you were saying, then we'd still be not following stare decisis. But let's hear from.
Thank you, Your Honors.
Good afternoon, Your Honors. Christopher Bellier from Gibson Dunn on behalf of the plaintiff respondents, Pearl Weinberg Partners. Stare decisis, that is the answer, 2 words to this.
Even if it may be incorrectly decided?
Sorry?
Even if it may be incorrectly decided?
It was not, Your Honor. In
Blindly?
fact, with due respect to you and Judge Higgett, who decided this 29 days ago, Canthith, I'm never going to say you did anything wrong. So it was not wrongly decided. And there's nothing in the statute.
Not that there's not room for growth.
There's nothing in the statute itself that says retroactivity, right? I mean, they could have said this amendment or this statute applies retroactively. They did not do that.
Well, what about your friend's point, if I understood it, that this isn't actually retroactive application? The case is in the pipeline, so to speak, and so we're just applying the statute to a case that's in the pipeline.
That, to me, that's nonsensical. The legislature doesn't clarify something and say, oh, for 10 years now it's been X. That has to be an amendment to the law. They don't just say, hey, I just want to let you all know on the bench you've been doing this wrong for 10 years. By the way, this is the worst case for you to apply this anyways. Mr. Kramer, Mr. Slonik are partners, not employees. There's a question in our mind whether the statute even applies to partners. They made a lot of money at Perella Weinberg Partners. Mr. Kramer himself made $50 million in cash comp over 8 years. The language in the statute, and my colleague, Mr. Edelman, said it made me read the entire legislative history, it only refers to employees. The word partner does not appear once in any of the legislative history. We don't even think it applies to them on that basis alone. This is the worst set of facts for you to actually go ahead and reverse stare decisis or your other 2 opinions. There's no reason to do it here. These men have all the protections they need. They have a breach of contract claim that is pending on this exact issue right now, and we are going to trial on April 29th on this issue. So they do not need the labor law to protect them on this issue. Unless there are other questions, I receive the rest of my time.
Thank you.
Thank you, Your Honors. I know I'm facing an uphill battle here, so I will gladly take the time I have. On the first point, just very briefly, I urge you not to decide this case on whether or not our clients are employees or partners. The statute has a wide-ranging definition of employees. Whether or not they were employees or partners, you must look behind the title. It's an issue of fact that's properly decided by the appellate court, not on this record. That's all I'm going to say about it, unless you have other questions. On retroactivity, I would urge you, as my colleague apparently did, to read through the entire legislative history on this question.
I'm just curious because, you piqued my interest here. How could we apply this in a way that it other wouldn't be deemed to be a retroactive application of the?
Here's how, Your Honor. I pointed you to the Regina Metro case, which is a 2020 Court of Appeals decision. It says, and I'm quoting, applications of a new statute, to conduct that has already occurred may, but does not necessarily have retroactive effect, upsetting reliance interest and triggering.
So that's the definition of retroactivity. And right,
it is
wrong,
not.
or otherwise, we have held, perhaps not, given the benefit of your briefs, but we have just directly held that it does not have retroactive application.
You have held that, Your Honor. And if I'm not making headway on this, I'll address retroactivity directly. It is difficult to conclude, in my opinion, that the statute was not meant to be given immediate effect to pending cases. And if you read the text of the legislative history, and we're not talking about floor debates where people said differing things. We're talking about abundant, written, uniform legislative history and statutory text that says, quote, it intends to immediately, quote, once and for all, quote, foreclose employers from being able to withhold wages without exception, quote, and, quote, make sure employees get paid what they are owed no matter what,
Can I ask
quote.
you a question?
Yes, of course.
Is your particular issue going to be mooted out by having this trial?
No,
It's
Your
still
Honor.
going to be a live issue.
It's a live issue. There are different remedies under the New York labor law than a contract claim. That's why both exist, and our clients are entitled to the benefit of both. you know.
I just wanted to know that in terms of
Absolutely.
going forward.
Yes, we are going to try this issue. We hope to be able to benefit from the protection of the New York labor law as well, which the legislature has made now abundantly clear in a clarifying amendment is intended to apply to all employees,
And do you
no
know
matter
if
what.
either of the other cases are up on appeal?
I'm sorry?
Do you know whether either of the other cases are up on appeal or
I
where
don't
they are?
believe so, Your Honor. I don't know for sure. I trust that we would have looked at this, and I don't believe so. And that's the last thing I'll say. To the extent that Your Honors, you know, are not inclined to rule in our favor, we would respectfully ask that you consider certifying to the Court of Appeals, because not only is this a very important issue of statutory interpretation that may be directed to that court, the Raparthy decision also breaks quite meaningfully
You're going to have a chance to make
retroactivity.
the argument about
Understood,
if
Your
you're
Honor.
unsuccessful.
You don't know, maybe you'll resolve it at trial. Why don't we wait for that?
One can hope. Thank you, Your Honor, for your time.
Thank you. Sid versus Kinale Capital Group.
Good afternoon, Your Honors. Ronald Hart appearing for the appellant John Sid. Your Honors, this is 2 points I'd like to make. One, we allege in the complaint this is really a negligent security case. As Sid points out in his affidavit.
Did you sue the security company?
We were not able to locate the security company. We did hire an investigator, so no, we did not.
Counsel, don't you have to look at the underlying incident? Like, what was the underlying incident that this claim arose from in determining whether the exception applies?
Well, I think that under the facts of this case, you have to look a little bit beyond. You have to keep in mind that in this case, the bar screened all the patrons that entered the bar. They had a metal detector. Sid brought to the bar's attention, hey, look.
Clearly, there's issues about about the security and whether or not that, but for purposes of applying an exclusion under insurance policy, the law seems to suggest that you look at the underlying incident which gave rise to the claim to determine whether or not an exclusion applies. So my question, I guess, is how could the underlying incident in this case not be the initial assault in the first instance, even if there might be a viable claim for negligence?
I think it's intertwined because I think that when Sid points out to the bar, look, to the company, look, this individual just punched me. They escort him from his point of view off the premises, but in fact they just escorted him downstairs. 5 minutes later, his face is cut apart.
But the whole claim arises from the assault. Right? The assault is what the claim brings the claim. And there's an assault and battery exclusion. I mean, it's not complicated exclusion. You can sort of try and pigeonhole it somewhere else, but it's a pretty straightforward, if any, no matter what you plead, if your claim arises from an assault, it's out. That's what the policy says. And we have interpreted that many, many, many times, as you know, right?
Well, Judge, I think it's also similar to like the case I cited in the brief, the Union Mutual versus Johnson, where the individual enters into the person's home. He shoots the individual, that's an assault, but they failed in that case to supervise, to intervene, and to prevent the assault. There's another case that, so I think is very similar.
I think the bar cases are pretty straightforward, and we all know that's why the bars put in the assault exclusion, because the confluence of alcohol and people often leads to this kind of behavior. That's what I'm saying. It's not like this is an unusual exclusion or an unusual event. This is a pretty straightforward common event and a pretty straightforward common exclusion, right?
Since you're talking about the bar case, I didn't cite a case, but there is a case, O'Shea versus Utica Mutual Insurance, which I believe is a bar case. And in that case, the court found that one, the non-assault claims were not barred by this assault exclusion.
Did the language in that, in the insurance policy in that case mirror the language in the insurance policy in this case? Which is clearly, unambiguously says that if it's an assault, it's excluded.
Right, it may not mirror it, but you know, so we have it, but they did have an exclusion, an assault exclusion. I don't know if it mirrored it exactly, but in that case, there were claims that were not assault, such as unlawful arrest. There was the Dram Shop Act. We have the Dram Shop Act here. This was basically negligent supervision. You can't escort this person out.
Counsel, could you have any negligence claim in the absence of the underlying assault? That's the question. Could there possibly be any negligence claim if the underlying assault had not occurred?
I think so. I mean, I think
What would be the basis for claim if he had never been assaulted in the first instance?
Well, it's just like in a regular negligent security case, right? I mean, if you, in this case, they intervened, they caused, in essence, the assault here, right? I mean, he goes to the bar and says, "Hey, look."
Right, and there may be liability, and there would be liability for the reasons you say, but that's not the issue. The issue is under the insurance policy, can there be a recovery? That's really the question, right?
Well, doesn't it come out to if it's an unusual and unforeseen from the perspective of Mr. Sid, right? So that if he thinks from his point of view, and I see my time is up, but if he sees from his point of view, hey, the harm and the danger has passed, I don't have anything to worry about. 5 minutes later, he's cut across his face. I think, you know, under the law, that that does come within that comes outside of the exclusion.
Thank you.
Thank you.
Good afternoon. May it please the court. Patrick Lawless for the defendant respondent, Kinale. This court is correct. The law is clear when applying an assault and battery exclusion in an insurance policy. The question is, would there be a claim? Would there be a cause of action if there was no assault? And that's how you apply it. If there was no assault, there would not be any claims in this case.
Would it matter that what I gathered from his argument was that the bar sort of like lured the plaintiff here to put his guard down when they escorted this individual away, and he thought that they were taking him out when in fact they took him downstairs and then he came back. Would that make any difference?
No, it wouldn't make any difference because, again, there wouldn't be any cause of action or any claims if it wasn't for the underlying assault. That's the key question in any of these cases, whether or not a assault and battery exclusion applies. So you look at this and you operate from that position. Would there be a cause of action without the assault? And it clearly in this case is no. According to the plaintiff's own complaint, according to the testimony he gave at the Inquisition, all his injuries, this entire claim arose out of the assault. And to the extent that he alleges dram shop actions and all these other things, there's also a liquor exclusion in the policy as well. But everything stems from the assault in this case, and therefore the court below properly held that the assault and battery exclusion applied. Unless you have any other questions, I'll rest on my brief. Thank you.
And all I'll add to that is I agree, this assault would not have happened because he did let his guard down and thought that the danger had passed, and lo and behold, he's assaulted. So I think unto itself, we've made out a claim. That's all I have to say.
Thank you. People versus Parker.
Good afternoon, Your Honors. Harold Ferguson for Appellant Joseph Parker. This case is controlled by this court's decision in People versus Jonathas. In fact, the facts in this case are particularly stronger than that in Jonathas. The only thing that the officer could point to indicate...
First, you have to start with a waiver of appeal,
Right.
because if you don't get past that waiver, then we don't even get to address the suppression argument, which is a pretty good argument, but how do we even get to that if
Well, Your Honor,
if there's
first
a
of all,
valid waiver?
if we take a look at what this court decided yesterday, what you had here was, first of all, a conflation of the rights that are waived by a guilty plea with the waiver of the right to appeal. And
But even if that's correct, and there's an argument for that, I agree. There was a written waiver here, which it's my understanding that was reviewed between counsel and the defendant. And so based on all the circumstances, wouldn't we look at both and to make that determination?
you would look at both, Your Honors, but there is nothing to indicate that the judge even took a look at this waiver. The waiver in this particular case was not.
But did defendant review the waiver with counsel before signing it?
Right, but the judge himself knows nothing that's contained in the waiver. The judge himself did not even sign the waiver. The waiver is
Didn't the
only.
judge make it unbelievably clear that the suppression argument was being waived?
But he made that initially when he was talking about the waivers of the rights by pleading guilty. He conflated the two together. He didn't say that it was
Don't we have a
separate.
line of cases, including from the Court of Appeals, that that's okay to have that conflation as long as the written waiver?
But you're also, Your Honor, the court made it clear that that the waiver that was in this case was an absolute bar to any appeal whatsoever. Told that it was a final determination.
You're talking about the oral colloquy, not the written waiver. Right?
Not the written waiver, but the.
No, wait a second. Here's what the court said. I've already indicated to you that you would be waiving the right to appeal your conviction. This will be a final determination and would preclude you from appealing the decision on the suppression hearing. He did say, he absolutely did say in connection with the appeal waiver that it was the appeal waiver applied to the suppression hearing.
But it also, within it, it began when he first mentioned the waiver.
No, but you just said a minute ago that he didn't. That's what I'm trying to clear.
No, Your Honor.
He said it in connection with the pleading guilty, and he also said it in connection with the appellate waiver.
And when you look at the continuation of that statement, it also includes that this was an absolute bar to taking of any appeal. And in Thomas and Bisona, if you look at Judge Garcia's concurring opinion in Bisona, he says that
he says on the record, did you have a full opportunity to discuss the waiver with your counsel before you were sick? So he said, and the written waiver, we both agree, separates out the right. Did you have the right to look at it with your lawyer before you signed it? And he said, yes, I did. So where is it that you're saying that he could have been misled?
he's misled because the judge did not ask what was discussed amongst counsel.
How could? Where is that required?
You're not serious with that.
Yeah, no, because no court requires that.
So you're saying give up my right to confer with counsel personally and my attorney-client privilege and tell the court what your lawyer said to you and what you said to your lawyer? No, I know you're not saying that.
No, I'm not saying that he waives his right to an attorney-client privilege.
So then you're not saying the judge should have asked him, what did your lawyer say to you and what did you say to your lawyer?
But there are cases that do indicate that that is something that what was discussed between counsel.
Well, definitely not required. I mean, you're not arguing that that's required under our case law.
No, but again, Your Honor.
Or else we'd be throwing out almost every single waiver.
Your Honor, when in Judge Garcia's concurring opinion in Thomas and Bisona indicated that any single error that is contained in the waiver of a right to appeal adversely affects it and makes it a non-waiver. And that's what Judge Garcia, who opposed the waiver issues in those cases, but concurred on the basis of previous cases, but indicated that a single error. And here, what the judge has told my client is that this waiver is an absolute bar to taking of any appeal.
And he also indicated that client expressly discussed the written waiver with his client, and the written waiver says, I understand it's separate and distinct. I understand it would have allowed me to do certain things. I understand that I still have certain rights, correct? He made sure that your client spoke to his lawyers about the written waiver and clarified anything that was unclear about the oral colloquy, right?
Your Honor.
And haven't we said in a number of cases that that's enough?
I understand, Your Honor.
Yeah.
All right.
Okay, thank you.
Good afternoon, Your Honors, and may it please the Court. Reva Grace Phillips for the respondent in the Bronx County District Attorney's Office. So I think your honors are absolutely correct that the waiver really bars and forecloses defendant's claim. And I just want to raise a few factors that support the waiver before I turn to the merits. So the first factor I would point out is not only is the written waiver brought up, but the court confirms that he's discussed it with his counsel 3 separate times. Additionally, to the extent that counsel's arguing there's conflation because the first time the court mentions the appeal waiver, that then goes into the trial colloquy. I note that on, I believe it's page 6 of the hearing record, pardon me, it might be page 7, it's page 7. The court specifies, by entering this plea today, you are giving up the right to file any appeals of the decision by the judge at the suppression hearing. So that's not conflating it with his plea by virtue of pleading guilty and the rights he's waiving, sorry. The other thing I would notice is that this is a defendant who has prior experience with pleading guilty to high-level weapons possession crimes. He has multiple prior felony crimes, so he certainly knows what it is to plead guilty and that he may retain rights afterwards. That's further
Well, if he's been
supported.
given deficient plea colloquies in the past, I don't think it would help him much to make an informed waiver in this case. We don't know what the content was of his prior colloquies on his prior appeals.
That's correct, Your Honor. However, none of those cases were successfully challenged on appeal. So if there were issues with the colloquy, I would have expected an appeal with an overturned case. I would also note this defendant quickly filed his notice of appeal, further indicating he understood he contained some rights after waiving his right. Now, really, that should, in this court's inquiry, the waiver of the right to appeal forecloses his claim. But this suppression court was fully justified in determining that there was founded level of criminality. And I would distinguish this from the Janathis case.
What possible founded suspicion could there be?
Absolutely, Your Honor. So I'll go ahead and I'll go straight to what I think distinguishes this from Janathis, because I think we have the 3 factors from, I'm sorry if I'm mispronouncing the name, Janathis case, and that's the out-of-state license plate, high crime area, nervousness. So we have those 3 factors. We know that's not enough. But here we also have this really peculiar exchange between the officer and the defendant, where after the officer is
What is peculiar about saying that my license and registration is in the trunk? I don't trust it in the glove box because people break into cars in this high crime. I don't think that's peculiar at all. I think a lot of people in high crime places put their personal information. I lock my purse in my trunk when I go to a high. Why is that unusual?
Absolutely, Your Honor. So I'll respond with 2 things. One, so I think the lead up, because this is, I think, counsel's trying to parse these separate moments so the court looks at them individually. But right before that moment is the defendant in the car. The officer asks, all right, I still need the rest of your identifying information. And the defendant reaches for the glove compartment and then he freezes. And this isn't, defendant doesn't turn to the officer and say, sorry, I keep it in the trunk. Sorry, I just moved it to the trunk. He freezes, looks at the officer shaking, and the officer says, are you okay?
Isn't
And
the
that's
law
when the
now
defendant
that nervousness is not enough?
So again,
And
Your
what
Honor,
you're
but we're
describing
building
as
out.
nervousness, and now that's the law, that's not enough then.
Again, to briefly build out, I think, the sequence here. Again, it's the shaking. The officer is the one who's going to ask, are you okay? Then defendant proffers, I keep it in the trunk. Can I get out and get it? And that's when the officer says, hey, before you get out of the car, anything on you or in the car that I should know about?
Right, but then it jumped up. Okay, but let's hear from opposing counsel.
Well, unless I get over the waiver, there's no hope for the substance of this. Again, Your Honor, if you look at his actual record and you look at his prison records, the last time Mr. Parker was in prison was in 1982. So that's his record was he did 4 to 8 years when he was incarcerated in 1982.
What about your adversary's point that, in fact, if you read the colloquy carefully, there really wasn't as much of a conflation as you're making it to be?
I believe there is, Your Honor, because when the court is addressing the rights that are waived by pleading guilty, he is also addressing the right to waive. He's waiving his right to challenge the suppression hearing. And again, I want to go back to that. What the judge has said is that this is a final determination. The case is over. There is no right to appeal. This case is done. And for my adversary who indicates that...
He didn't say that. Were not his words.
The court says at the end of the case that the case is now over. And it also said it was his final determination. But as to one other point, the fact that there was a notice of appeal filed. The notice of appeal is not filed by Mr. Parker. The notice of appeal is filed by the Legal Aid Society. As a matter of course, in any felony conviction, our office files a notice of appeal, irrespective of whether there is a waiver issue or not.
Thank you.
So the fact that there is that does not indicate that Mr. Parker thought there was a right to appeal. Thank you, Your Honor.
Rock Group versus certain underwriters.
May it please the court, Michael Panayotou for Rock Group, the appellant. Respectfully, the Supreme Court erred in denying Rock Group's motion for partial summary judgment and granting underwriter's cross motion based on the auto
So
exclusion.
why isn't the exclusion clear? It's an auto exclusion for unloading and loading from a vehicle.
Correct.
Why doesn't this case fall squarely into that exclusion? It was clearly an automobile, and he was clearly in the process of unloading when this accident occurred, and it was because the unloading was occurring that this accident occurred. So how do you get out of the exclusion?
Correct, Your Honor. There's a third part to the test, and that's what matters here. The third part is that there must be some connection of the vehicle itself must produce the injury, whether through an act or omission of the vehiol. It's not just mere loading and
Right, and
unloading,
we
that's
addressed
enough.
that in Zurich, which seems pretty much on point here in Zurich. What was the connection that was required? And it appears that they made a similar argument in that case to the argument you're making, and our court said, no, that's clearly the process of loading and unloading. That's covered by, so how is Zurich distinguishable from this case?
Sorry, is Zurich versus Ace American? That case? Yes. Well, I think that's a little different because in that case, the rebar was on the truck, the ties were being removed, and the rebar fell off the truck. So the vehicle is very connected to the alleged accident in that case. In this case, the gentleman, the claimant, was allegedly just standing on the truck, handing beams up to a coworker who wasn't on the truck. The fifth beam, I believe, was dropped by the coworker, fell back on him, caused an alleged injury.
Isn't that clear that the injury arose from the unloading of construction materials from the flat?
I think it does, but it wasn't caused by the vehicle. The same result would happen if the gentleman was on a platform or a box or anything like that.
But the same argument could have been made about the rebar, that it wasn't caused by the vehicle. But the question is, did it occur in an automobile while things were being loaded and unloaded from the vehicle?
Well, I think the difference...
And that's the test we applied in Zurich.
I understand, Your Honor. I think with respect to the rebar case, the rebar fell off of the truck. So the truck was the height, and the ties were removed, the rebar fell off. So that's what caused the injury. You know, there's some cases from the First Department, which I think are very on point here. Tishman versus Zurich, which we cite in our brief. There was a loading and unloading in the process, but the gentleman fell on a hole that was not connected, obviously, to the vehicle. The auto exclusion did not apply there. We have that on page 17 of our brief.
How analogous is that to our fact pattern?
I think it is analogous because in that case, in the Tishman case, the vehicle did not cause the injury, just like in this case, the vehicle itself did not cause the injury.
Okay, so let's the causing of. Where do you get the causing of language? Because when I look at the auto exclusion, it says bodily injury, property damage arising out of the ownership, et cetera, et cetera. So I think that's the same language in Zurich. Isn't that what we focus on what the auto exclusion says?
The exclusion is the same. It's the standard CGL language. The cases that we cite, U.S. Oil Refining versus Aetna, on page 16 of our brief, the Getz case, which is page 17, they require that the vehicle produce the injury itself. And I think it's important to note that the case that the Supreme Court relied on, Transl Elevator, which we discuss on page 18 of our brief, that involved a defective lift gate that was permanently fixed to the vehicle. That allegedly failed, and that caused the alleged injury. That's part of the vehicle. There's a much closer connection to the vehicle to make it fall within the auto exclusion. Here, again, the gentleman was standing on the truck. It could have been a box. It could have been a platform. There's no allegation that the brakes failed of the vehicle. There's no allegation that the materials fell off of the truck, that they were improperly loaded, that the car shifted. Anything having to do with the vehicle, there's no allegation of that. So the fact that the gentleman was standing on the vehicle when the alleged accident happened under Getz, American, U.S. Oil, Transl, and Tishman versus Zurich, all those cases, as well as ABC Incorporated versus Countrywide, which was also a First Department case, discussed on page 19 of our brief, there still must be a negligent use of the truck in order for the auto exclusion to apply. That's not present in this case. And
what was the negligent use of the truck in the Zurich case?
In the Zurich case, Zurich
Yes.
versus Ace. Again, I believe when the rebar, when the ties were removed from the rebar fell off of the truck.
But was the negligent use of the truck?
Well, I think it could be a negligent use or an act or omission related to the vehicle.
That's what it is.
What you're arguing is that in that case, there was mishandling of the equipment.
Well, but the
Which is
vehicle,
similar to
when the rebar rolls off of the truck, it's much more connected to the actual auto than someone standing and the gentleman who's not even on the car drops the beam allegedly back on.
Just seems like a distinction without a difference.
I respectfully disagree, Your Honors.
Fair enough.
Thank you.
Good afternoon, Your Honors. Craig Rockison for the respondent. Rock Group goes through, yes.
Just address counsel's argument specifically, head on. What counsel says is it has to be connected to the truck, and there's no connection to the truck here.
He was on the vehicle, literally using the vehicle to prop himself up to the height that he was at when the accident occurred. That's how the injury results from the use of the vehicle.
Does the exclusion also include loading and unloading?
Of course. The
Right?
exclusion.
Would this
yes.
not
So,
be straight up loading and unloading?
So the only thing that I really want to say, other than addressing any questions, is that Rock Group goes through great lengths to try to convince this court that an accident occurring on a vehicle during the unloading process does not arise out of the unloading of an auto. I think that that's basically it. There's no temporal or spatial separation between the auto and the injury. And
how do you distinguish the cases that counsel refers to?
Oh, well, these cases occurred in apartment buildings, in premises liability.
How connected were they to the truck?
Poles. How connected? Exactly. They were not connected to the truck, as opposed to here, where the truck was the location of the injury, the sine qua non of the injury, and of course, things are unloaded from trucks. That's why the loading and unloading is included in the definition of use of an auto in the auto exclusion. If there aren't any other questions, I concede my time.
Thank you.
Just very briefly, Your Honors, to quote, again, Tishman Construction Corporation versus Zurich, First Department case, 2022, 204 AD 3rd, 623. While use of an automobile includes loading and unloading, that's not disputed here. An accident does not arise from the use of an automobile merely because it occurs during the loading or unloading process, but rather must be the result of some act or omission related to the use of the vehicle.
Right, he's on the truck while he's unloading and loading. It's not so sure if he unloads the vehicle and then 12 feet away he slips and falls, which is not what's happening here, then you might have an argument. But he is in the process of loading and unloading on the truck, right?
That's correct, but that's...
I don't know how that's not straightforward.
Well, I think, Your Honor, respectfully, the standard requires some act or omission related to the vehicle itself failing or being negligently used in order to cause the alleged injury. Some of the cases that counsel cites, for example, American European Insurance Company, the brakes failed in that case. That was the allegation. The claimant fell off.
Why wouldn't the auto exclusion be written in that way, that the exclusion would apply where there is negligence, as opposed to more broadly that it has to, the bodily injury has to arise out of the use or operation?
That's a fair question. I don't know why it would it's not written in that way, but this is our position is that this is the way the exclusion has been interpreted for quite some time by the First Department, not just Tishman and Transl Elevator, but ABC Incorporated, which we cite on page 19, as I said in my brief. But I think the common theme of the cases cited by the respondent is that there's much closer of a connection to the vehicle failing or some sort of negligent use of the vehicle than in this case. And I respectfully request that the decision be reversed. Thank you.
Thank you. 101 East 16th Street versus DHCR.
May it please the Court, Assistant Solicitor General Kwame Akosa for the Division of Housing and Community Renewal. The reversal is required here because the Supreme Court's decision is directly contrary to this Court's intervening decision in matter of 4040BA. And there are no factual distinctions between this matter and that matter that would require a different result in the factual record present here. In both cases, the homeowners filed MCI applications before the HSTPA took effect. They completed their building improvements before the law took effect, but the applications were pending on the day the law took effect, and the agency determined.
Any arguments being made here that were not made and addressed in the decision in 4040BA?
No, Your Honor. As far as I'm aware, nothing has been raised in response to our brief. There was an argument that wasn't raised in the administrative proceedings that was raised for the first time in the respondent's brief. That's the undue hardship argument. That was raised in matter of 4040BA, but here the argument is even less persuasive because there hasn't even been exhausted. The request for a remand hasn't been exhausted before the administrative agency. There was an opportunity when the petitioners filed their petitions for administrative review to ask the agency to remand to the rent administrator to make a determination about an undue hardship as a result of the change in law. No request was made at that stage, and now at this late date, the petitioners are asking this court to give them that relief, and that request should be denied. If there are no further questions we would reserve the remaining time for our rebuttal.
Good afternoon. It's a pleasure to be here. I'm Robert Goldstein, and I'm representing 4 LLCs.
So this is our second stare decisis case today, which is not,
I'll get
it's
to
not
that
normally
really
our bread and
quickly.
butter
I'll
here.
get to that really quick.
But how do we get around, even if we wanted to address the merits, how do we get around that we just very recently decided a case which has the same
Firstly, I
exact
just have to
issues?
convince 3 of you that the other 2 were.
And I'll say, since I was on the other case, anybody who's going the other way?
I think they're all to this side.
Exactly.
Look, I've prepared something and I'm going to say it. I've got a few minutes and I hope that if my client is watching, he'll know that I gave him everything that I could, okay? The decision that was written in 40, it says the following. It says, DHCR rationally concluded that the amendment to STPA should be applied when considering petitioner's application or effective and applied to any determination after the act's effective date. Well, that's simply not true. The law didn't provide for that. And in 2019, we know that the real estate industry had virtually no input into the 2019 law. So the people who were drafting this could easily have written that it should apply to those pending matters. They didn't. And the reason that they didn't was because probably they realized that there were really due process issues. Now, there are cases, one of them is...
Okay, so then I've got to ask you.
All right, I'm not going to go into the cases.
What due process right do you think you have?
I'm going to say that, Judge, and that was my next point after the other point that you just stopped me from making. And
I'm sorry.
No.
I don't want to interrupt you.
It's fine. It's fine.
But you said...
The case law gives you a lot of leeway, but in certain cases, I don't think you have that leeway. My client invested approximately $1,400,000 in these improvements to the building. This client did this in reliance upon the fact that there was a formula that was to be applied, which would have given my client approximately $15,000 a year more if they had applied the old law. So there is a taking here, and the question is, was it necessary to do this? What was the policy issue that was determinative of this? Well,
may I just ask you then one question? What happened if the MCI increase was denied? How much would your client have gotten then?
Less.
None. Nothing, right? So it wasn't a right that was available right at the time. You didn't have your client didn't have a due process. Your client had a due process right to the procedure, right? And the DHCR could have said you didn't prove it up at all, and therefore you get nothing, correct?
I understand that could have been the outcome.
So the idea that you have your due process right is the
difference between what they did was twofold. Number one, they took away the actual amount of the money, okay? And then secondly, they lowered the cap on what the tenant would have to pay. So between those two things, it's almost impossible to calculate the monetary loss by this change. If the legislature had wanted to apply this retroactively, all they had to do was say, this shall apply to all pending applications. They didn't do that, and the reason I think they didn't do it is because they realized that that had an issue. So what happened is the DHCR decided that they were going to do what the legislature didn't do. They just decided that that was what they were going to do. So it's
Well, sir, I guess this ties into Justice Scarpulla's question. Did the right have to be vested?
I think if my client invested $1,400,000 with the expectation, that's the James Square case.
Well, so, okay, that's a fine, I think you're absolutely right. An expectation that we have this regime, this scheme for the MCIs, and so I have an expectation that if I do X, I will get Y. But I guess does the law require there be a vested right? Something that is clear, not inchoate or conditional, but something that is firm in hand.
The James Square case is right on point. The James Square case deals exactly with what was done here, except in a different area of the law. And it's interesting because the James Square case, if you read it, it says that there was a draft which had made it applicable to all of the prior years, and that was not included in the final law. So again, look, vested right is what you people say vested right is in these kind of cases. It's a balancing question. And here, my client invested the money. He expected to get this. The DHCR could just have easily interpreted this to say it's for pending applications that were filed after the date of the effect of the law. They didn't have to say it this way. And with a 2% cap that they put on going forward, and with the amortization schedule, all they've done is they've disincentivized landlords from making these kind of improvements. So again, this is not a big issue for the future because there were, let's say, 1,000 applications. Now, just so you know, the decision of this court is subject now to a motion in the Court of Appeals for leave to appeal. So again, just I guess keep that in mind and see what happens with that. Again, to the left over here, hopefully, I can get to the Court of Appeals if I can't get past you. And again, it's been a pleasure to see all of you and be here. Thank you.
Thank you very much.
Thank you, Your Honors. I'll be brief. So the James Square case is not applicable here. That was a case involving tax penalties that occurred for 1 year prior. So here we're talking about a prospective rent increase. It's purely prospective. There's nothing here about prior conduct that's been penalized. And then about the legislature, as this court held in matter 44BA.
What about the point of the owners that they sort of relied on this procedure, and that there was an expectation of getting a certain return, which they're not going to get, understanding that obviously DHCR at the end would make a determination.
Well, Your Honor, it wouldn't be enough to say that there was an expectation. They would have to be shown that there was a vested right at afoot here. There's something that can show that the time.
And are there cases that would support that there's a vested right, for example, to a future MCI increase?
Not in the circumstances such as this, where there was no pre-existing MCI order at place. All that existed was the MCI application, which was currently pending with the agency. And so the agency had an independent duty to assess that application, determine the eligibility. No right could possibly have vested under those circumstances. If there are no further questions, thank you, Your Honors.
Thank you. People versus Tapia. Welcome back.
Good afternoon, Your Honors. Again, Harold Ferguson for Appellant, Felix Tapia. At least can't lose this one on a waiver. We have to take a look at the difference between the original testimony of the officer and then what he corrected it to be. If the original testimony went unrebutted and he didn't correct it, we would likely lose this. But what you have here is when he corrects it, he indicates that he sees two individuals talking for about 10 to 15 minutes, innocuous. Another woman.
Does he recognize one of the individuals?
He does not recognize either Mr. Tapia or the woman.
He doesn't recognize one of the, I think it was Ms. Rivera?
He recognizes a second woman who comes up.
Right, so let's focus on Ms. Rivera, because that's what this case is about. So he recognizes Ms. Rivera as?
As someone that he has arrested once for drug possession.
And doesn't he also testify that she was, that he knows that she was arrested twice before by another officer?
Yes, but
So three arrests, correct?
Right, that he has been arrested for drug possession, and that Ms. Rivera has a discussion with Mr. Tapia for 2 minutes, and then there's she handed him something. He acknowledges...
Well, they touch hands.
They touched hands, and he does not see any money. And then Ms. Rivera walks away. Mr. Tapia continues talking to his original partner, and then eventually Ms. Rivera returns. And originally he says, I saw Mr. Tapia hand Ms. Rivera crack cocaine in a Ziploc bag. And then he changes it to, actually all I saw was he put his hand on top of her.
Well, but before that, doesn't he reach into his pants?
He reached into his pants.
Where does he reach? Based on, I was trying to figure out.
That he reached in the back and pulled his hand out.
Is it the back or the side?
It was in between his pants and I guess
halfway,
his body.
I think. Halfway, right?
Yes.
Halfway?
So he reaches in, but...
Where does he reach? Into his pants?
No, he reaches in between his pants and I guess either his physical body or his underwear.
And then what does he do after that?
He pulls the hand out.
And then?
He does not see him having removed anything from
But immediately right after that, what does he do?
Doesn't he place, let me answer the question, doesn't he place his hand on her hand?
No, what happened is when he pulled that out, that was while Miss Rivera was away. After the original exchange with Miss Rivera walks away, then he reaches into his pants, but the officer doesn't see him remove anything or even look at his hand or to see if anything is in his hand. And then when Miss Rivera comes back, all he sees is, as he corrects himself, is he puts his hand on top of her hand, and then she walks away.
And does she clench her fist?
She has a clenched fist.
What would that suggest to you?
That I have no idea what that suggests.
And does she throw something when she
Right.
throws something?
She
They
throws
see it,
something.
right?
But again, originally what he testifies to is, I saw her discard a pink Ziploc bag of crack cocaine, but then says she threw away something. And what's important here is the something is not determined until after both are arrested.
But then, so what you're saying is essentially that simply because he didn't, after he thought about it, couldn't say for 100% it was drugs, that's not a good stop. Is that your point?
Absolutely, Your Honor. And it wasn't that
So
100%.
you're saying that that little glassine thing, you have to actually see that it's drugs in order to make it a good, reasonable cause?
Your Honor, again, this wasn't a reasonable cause. This wasn't a reasonable
reasonable,
But again,
right.
he says she discarded something. Originally, he says, and again, we have to look at the credibility of the
Don't we have to
officer.
look at the totality of the circumstances too?
Yes, you look at the totality.
So, a drug-prone location, a experienced officer in narcotics, correct?
He had a little bit of training and about 100
Okay, that's factor two. Third factor is someone he recognizes who's involved in consuming drugs.
Yes.
And then the movements in the hands, and then the touching, and then when the police approach, the person discards the object. You're saying that they have to know that the object in her clenched fist was crack cocaine or some illicit substance.
But again, we're looking at how he changed his testimony. He changes his original testimony was to nullify a constitutional.
Counsel, may I interrupt you for one moment in saying, are you saying that we should discard the trial court's credibility determinations?
Yes, Your Honor.
All right, that's all.
I believe
That's
we
it.
should.
If we don't, and we accept that the trial court found the officer's testimony credible, that there was something there that he saw pass back and forth, then we are done, correct? So then it's reasonable suspicion.
Well, again, and again, what I want to get to is, it's what did the police know at the moment they acted? If the officer had looked to the ground and saw what was discarded and saw it as being crack cocaine, we likely lose. But what he saw was something was discarded, and it wasn't determined to be crack cocaine until both were arrested.
Would you have
we don't know the circumstances of Mr. Tapia's arrest because the two officers who arrested him were did not testify at trial. And also, even though the people have submitted to this court a photograph of the scene, please understand that that was taken during the day. What was observed was at night in front of a seedy motel with limited lights and through tinted windows.
What I'm just trying to clarify, in order for us to find for your client, we would have to discard the trial court's credibility determination, right?
I think that would make it easier for us.
I
but
mean,
think
that's my question to you.
I think-
Am I going to have to say that the trial court's credibility determinations were incorrect?
in order for us to prevail?
Yes.
No, I think based
How
on
could we?
based on the facts that are there, that they didn't. Again, if you look at this court's opinion in Ayarde, which says when you haven't seen any type, you cannot identify the objects that were exchanged, and that what you have seen is not furtive behavior. What you have is, and again,
Is it usual for people to just stick their hands into their pants and then, pat people's hands and people walking away with clenched fists? Is that
and
normal
discard
behavior?
if it was instantaneous, that would be something different.
Oh, wait, let me finish my question. Is that normal behavior in a drug-prone location, as opposed to, say, if it happened in the leafy environs of Columbia University?
I don't think we need to get to that, because all he's doing is you're adjusting your pants. Does not indicate that he's removed something from
The testimony doesn't say that he was adjusting his pants.
He
Testimony
said he
saying-
reached into his pants.
Right.
Thank you.
Does it?
Well, time out.
Can I?
Go ahead.
Do you need under the scenario where someone touches someone else's hand and the other person walks away, clenching something? Do you need more than that in order to reach the level of probable cause to arrest the person that passed something over?
Again, Your Honor, there's not evidence of passing here. What you have here is hand on top. Again, if it was an exchange, that would be different. But hand on top of
Can you
hand.
answer his question?
Yeah, that's what we
He
want to
asked you a
know,
very
yeah.
specific Question. So can you answer actually the question that he asked?
Could you repeat it, Your Honor?
Do you need to have, like you said, found that the object that was passed was actually drugs, or do you need to have seen some money exchanged in order to have reached the level of probable cause to arrest?
Yes, Your Honor. I believe you needed either to have seen that it was currency or that it was drugs. Here you have nothing that indicates.
And it's
that
not
any-
sufficient. It's not sufficient that, in fact, an object was thrown to the ground before the arrest. That's not sufficient?
But again, Your Honor, we don't have that he handed. There is nothing in the record.
But you're isolating it. I'm looking at based on totality of circumstances. You're isolating each transaction as a separate transaction, or each part of it.
But Your Honor, I think you're making a leap of faith, indicating that from this and this constitutes that she's accepted something from him. There's nothing in the record that indicates that he saw anything exchanged between.
No, he did. He testified. I saw him put something in his hands. I can read it. I mean, we've read the transcript, but I want to ask you, you just made a statement that you either have to see drugs, actual drugs, or money. And can you tell me what case says that you absolutely need one of those two things?
There is no case that said there is an absolute requirement of it. But
okay.
again, if you go back to the totality of the circumstances.
No, I'm just asking you about that question, about, because
no
the question
specific-
is, if I saw an object, if I saw this whole thing happen, right, but I didn't actually see money or drugs, I saw an object and everything else that happened, whether that's enough. And so my question to you is, do you know of any case where the kinds of things that we saw, but they couldn't actually say it was drugs or money, where the court said that that was insufficient for a level of probability to go
We did
forward?
cite a number of cases. in
Yeah,
our
but
brief.
none of them
say
that.
the exact
Thank
thing
you
that
very
you're
much.
talking about.
Let's hear from.
Good afternoon, Your Honors. For the people, Jacob Marcus. Just to respond to a couple things, because this case does turn on this interaction. The defendant, Ms. Rivera, didn't speak for 2 minutes, as opposing counsel said. They spoke for 5 seconds before she handed him something and did a lap up and down the block.
But you would agree that the police officer clearly, when he was the court was asking him questions, his testimony sort of was massaged a lot about what he actually saw.
I don't know if I would say massaged, Your Honor. I think this is a case of him putting the cart before the horse. After the fact, after having recovered these drugs, having learned what that object was, he testified, I saw him pull out a bag of crack cocaine, hand her the bag of crack cocaine, because after the fact, that's what he learned had happened. And then when the court, sua sponte, asked him to limit his testimony to just what he saw in the moment, and when defense counsel had an opportunity to interrogate that on cross-examination, he was totally candid. He said, okay, in that moment, I didn't see what it was, but I saw
What did he
this.
see specifically? Why don't you tell me what the timeline is of what he saw?
So first he sees Ms. Rivera, whom he and his partner had arrested a total of 3 times for narcotics possession, approach the defendant. They have a 5-second interaction. He says something to her. He doesn't hear exactly what it is, I don't think. And then she does this lap up and down the block as he fishes something out of his pants.
And let's talk about that movement. What is he, we've all read the transcript. We're trying to understand what it says.
Yes. To Your Honor's earlier question, the officer doesn't say front, sides, or back, but he reaches in between his pants and the body. That is like not the pocket. To that extent, he withdraws a closed fist and then touches hands with Ms. Rivera. I'll note that the detective does pantomime something, and despite the hearing
Is there anything in the record that says that he withdraws a closed fist or he pulls his hand out?
I believe,
Plain and simple.
I believe the record says he pulls something out in his fist.
I read this transcript more than 3 times, and I didn't see that anywhere.
Yes, Your Honor, that's...
Yeah, let me see. Okay, that's a good point.
He pulls something out, he doesn't look at his hand, and the officer doesn't know what it is. Actually, he doesn't even say he pulls something out. He pulls his hand out.
Yes, Your Honor. So on pages 11, 19, and 38 of the record, that's where the witness addresses this moment. And he initially says that he retrieved a small object, which again is something.
But then he takes that back.
Right.
You agree?
He does say, but he does say that he held in a closed fist. So
Where does he say he held it in a closed fist? What page?
Sorry, I'm jumping between the record and our brief. I think that is page
11, right? His right hand fist was closed and his left hand around the wrist.
That's when you say he put the cart before the horse, because this was all after the fact.
Well, I think saying it was an object was putting the cart before the horse, but the fact that he saw a closed fist, I think, is exactly what he saw in that moment.
So, and then let me ask you one question, which I asked your adversary. Would we have to discard the court's credibility determinations here to find that that there was not probable cause for the arrest and then the search?
Well, I think opposing counsel makes the argument that even accepting the facts as the officer testified, it's their argument that there still wasn't sufficient probable cause. So I don't know if I would go that far, but in any event, I don't think there's any reason to discard his testimony. Of course, the standard is self-contradictory, manifestly erroneous, and here just putting the cart before the horse, I'm sorry to harp on the phrase, I don't think meets that standard.
What happened? I'm sorry, go ahead. What happened first? Was the defendant placed under arrest, or did the woman who was involved in the transaction throw the object to the ground? Which happened first?
That is unclear from the record because at this point they have separated. It's our position that probable cause vested at the completion of that interaction.
Not at the throwing of the object to the ground?
I don't think the record is clear on the timeline of whether they had seen the object thrown to the ground when they arrested defendant.
He was already under arrest. She threw the object to the ground, and he was arrested basically simultaneously.
Yeah, so they were approaching defendant 25 feet away. Ms. Rivera was 5 feet away. So I think it's plausible that she threw that to the ground before defendant was arrested.
But ultimately then, the finding of whether there was sufficient evidence adduced before the suppression court to satisfy the level 4 intrusion cannot turn on her act of throwing that object to the ground.
I don't think it needs to turn on that, Your Honor. I
But
think
it
that
cannot,
given-
apparently. I appreciate that concession, but it sounds like it cannot because there isn't support one way or the other for, it's unclear, I think you said, whether she threw that, because
No, let me just
It's
say.
unclear whether or not
He testified.
whatever object she threw to the ground was narcotics at that point.
Excuse me, Your Honor?
It is unclear at the point she throws the object to the ground whether that object is actually narcotics.
At the moment she throws it to the ground, yes, they
Right,
learned that
but
afterwards.
at that moment, at that very moment, Mr. Tapia is being handcuffed so that he's under arrest.
I see my time is up. May I respond, Your Honors?
Yes.
It's unclear if he was being handcuffed at that very moment. Of course, as I mentioned, Rivera was much closer to the officers than defendant was, so I think there's some difference in time. But to return to your question, Your Honor, I think that we don't need that to satisfy probable cause. Here you have an apparent buyer whom the officers knew to be a repeated user of illegal narcotics. You had not just a neighborhood, but a motel specifically known for narcotics trafficking, a block radius within which this officer had arrested 10 people in the prior 6 months for narcotics. And then you have this interaction that is unequivocally the exchange of,
According to the officer, what he saw was that they touched hands.
Yes, Your Honor, and this court has held.
He didn't see money go from Ms. Rivera to Mr. Tapia, and he didn't see an object go from Mr. Tapia to Ms. Rivera.
Well, he did testify he saw an object, and the hearing court actually credited that in their finding of facts. They specifically noted that he did see an object. You're right, he never said that he could see what Rivera handed defendant, but this court has held numerous times that he doesn't have to specify that this was drugs or it was a glazing envelope. In Tinnin, Graham, Schlake, O'Kane, Jack, over and over again, this court has said that seeing drugs or seeing drug packaging is not the sine qua non of probable cause, and instead it's the totality of the circumstances. Here, the totality of the
Do you have any more
circumstances.
questions? Okay, thank you very much.
Thank you, Your Honors.
Just a couple of points, Your Honors. The officers did not know Mr. Tapia at all. They had never seen him before. And when the other two officers stopped Mr. Tapia, they not only stopped Mr. Tapia, they also stopped the woman he was talking to, and both of those individuals were searched. And back to your point earlier, Your Honor, the testimony is that it was only after he stopped Miss Rivera that she then attempted to discard the object. So you are correct. Mr. Tapia had been arrested before that was, based on the record that it was discarded after Mr. Tapia was arrested. So that can't play a role at all. And again, to go back to, you really have to take a look at, the cart before the horse is, I think, a colloquial expression they're using here.
May I, when the witness says, I stopped Carol and they stopped Tapia at the same time, not like a month later or 10 minutes later. It all happened at the same time. And they said, open up your hand. She threw something on the ground, right? We all agree. I'm looking at the testimony.
That
Do
is
we
correct,
agree?
Your Honor.
Okay.
But he was stopped
So
before
it's
she discarded.
simultaneous.
But he was stopped before she discarded the object.
Oh, okay, fair enough.
So they had no idea what she had in her hand at the time.
That's correct, Your Honor.
the
They had-
officer, I'm sorry, go ahead.
No, you may continue.
The officer who arrested defendant, who was not the officer who testified at the suppression hearing, he or she would not have known, or there is at least nothing in the record to suggest the arresting officer of the defendant knew that Miss Carroll threw the object to the ground.
That's absolutely
prior to the defendant being arrested.
That's absolutely correct,
Thank
Your
you
Honor.
very much.
Thank you, Your Honors.